I'm going to pick up now with your response to the Hemophilia Society report that we looked at earlier. So we're moving now to March 2003. So could we have please DHSC 0042275_124. So just to remind us of the chronology, we looked at the report earlier and the briefing that you got for a meeting with the Hemophilia Society for the 12th of June 2002, and we're moving forward now to March 2003, and we can see here a note to you from Rob. Is that Robert Finch from your private office?
Yes, it is.
And it says this: Hep C compensation. Officials have asked for a further steer from you on this issue. When we last got an update, you thought it important that we wait to see what the legal position was before proceeding, and then sets out what the position is in relation to the law officers. And then if we skip down to paragraph 3, we can see the points made that it's been 9 months since the Haemophilia Society presented their proposals. And then if we look at paragraph 4, we see that it says that given the continued delay, officials are advising that we now reply to MC, that's Michael Connerty, saying firmly that there is no prospect of any form of special payment scheme being agreed for haemophiliacs in England. We would therefore not be taking up MC's offer of a meeting to discuss the Haemophilia Society's proposals in more detail, although we are very grateful for all the work they have done, etc. Are you content to write to MC on this basis, or do you still wish to wait for clarity on the legal position in Scotland, accepting that there is inevitably going to be a further delay? And then you have written, is this right? Is this your writing?
Yes, it is my writing. Yeah.
You've written, I'm happy to be firm on this issue. One, I think we have to show we have properly considered the HSOC submission as we said we would. Two, SOS needs to be aware. Is it right to understand this note as effectively the only decision you're being asked to make is whether or not to turn the Haemophilia Society down now, or whether to wait and see what happens in Scotland?
Yes, I think there is another note, and I think I'd written on that. We need to wait for Scotland. But clearly the matter's becoming pressing, and officials, understandably, are asking for a steer from me on where we go with this next. So this is my response to that. I think I would just make one comment. I've written here, I'm happy to be firm on this issue. I think the word happy is unfortunate in retrospect, and I think I would have rather have said I am content, because what I meant was not that I'm happy about this decision, but that I know that there's a need to make a decision, and therefore I'm content to, if you like, hold the line that Secretary of State and Minister of State and was generally wanting to adopt. The second point I make is that I want to make sure that we have properly considered the Haemophilia Society's submission, which I think we did, but in view of the length of time it had taken to respond to that, again, I wanted to show them a degree that they'd earned respect because of the work that they put in. We were unable to accept it, but they put in an awful lot of work to do that. And obviously, Secretary of State was very involved with this, and therefore I wanted him to be aware.
So that paragraph 1, it could be read as as meaning we haven't considered the submission yet, but we need to show that we have. Is that not what you meant in that paragraph?
No, because I had considered the submission in detail, as I hope I illustrated in my answer to your earlier questions. What that means is not, if you like, show on a surface level, but actually be able to exhibit the fact that we had considered it.
And I don't think we need to go to it, but as a result, I think of this, you get a briefing which goes through the costings of the proposal from the Haemophilia Society, and that for those that are listening and for the record is at DHSC 5320619, and that submission appends to it letters for you to consider sending to the Haemophilia Society, effectively saying, turning down the proposal and saying no compensation scheme. Is that right?
Yes, and I'd already had details in previous briefings about the likely cost of the proposal that they set out in their report.
And the letters that you, well, at least the most final versions of the letters that the inquiry's been able to find are, again, we don't need these on screen, but are DHSC 5320618. And you tell us in your witness statement that those letters came to you for approval on the 16th of April 2003, there having been some previous drafts that you'd asked to be amended to make them more compassionate in tone. And the final draft of the letter you think came to you on the 16th of April 2003 and so would have been sent out shortly after that. Is that right?
That would be my understanding, yes.
And can you tell us why it was that it took so long for you to respond to the Haemophilia Society? So they submit their report in June 2002 and you respond in April 2003.
Yes, it's a very long time, I agree, to respond. But that's in the context to the discussions that were proceeding, both in terms of the Secretary of State, Minister of State, officials, myself, about what would be the appropriate response to the report. And so I think it was John Reid, in giving his evidence earlier on, said that the Health Department didn't necessarily have a reputation for moving things around that quickly. But I agree that that is a long time for people to get a response. But as I recall it, there were previous submissions about the tone of the response that there should be. So there was a lot of consideration given to trying to, I suppose, position this in the right place. But that's why I made the note that we should be able to show that we've taken what they've done seriously, so that this isn't simply a matter of dismissing the recommendations that they've made.
So is it right to understand that you were having sort of high-level conversations and discussions with more senior ministers about whether there should be a compensation scheme or an ex gratia scheme for those with hepatitis on a sort of broader level? But the question of the Haemophilia Society report and their proposal for that scheme was a matter for you to consider and wasn't something that was escalated to more senior ministers.
No, I don't think I am saying that. I think the fact that the Haemophilia Society scheme amounted to, I think, £522.6 million over 10 years was a matter of concern to the Secretary of State and to the Minister of State, and how that would impact, if you like, on the budget that was available for the rest of the health service. And so it wasn't simply a matter for me, and I'm not seeking to avoid any responsibility at all, but it was not simply a matter for me. The proposals from the Haemophilia Society were also caught up in that general discussion, which was, if you like, the backdrop to that was if we have a no-fault system with lots of exceptions to the rule of negligence, then we get into a difficult position with regard to the financial impact that there is on the rest of the money that's available for the NHS and for services.
I'm going to ask you questions now about calls to hold an inquiry. And I just want to do it, first of all, by reference to something you say in your witness statement. So in your witness statement, you say this when you're being asked questions about public inquiries. You say, I felt the facts were not in dispute sufficiently to warrant a public inquiry. And I just wanted to ask you what, if you can recall what your view was about what the threshold for holding a public inquiry was at that stage.
I think I would have thought, and I think I did think at the time, that a public inquiry clearly was a significant step. Public inquiries traditionally have taken a very long time to resolve, and that's no criticism of the inquiries, but by their very nature, would take a long time to proceed through the system. I obviously took into account myself that there had been debates in both Houses of Parliament, that I had responded to the debates in the Commons. There'd been a whole series of parliamentary questions that were considered and answered in both the Lords and the Commons, and that the idea of having a public inquiry would again extend the period of time that was involved in dealing with these issues.
But what did you have an idea of what the threshold for a public inquiry should be?
I don't think I'd actually dealt with a public inquiry in my previous role. This was my first ministerial role, so well, my second ministerial role, but at Parliamentary Undersecretary level, I had never been called upon to think in detail about what would be the threshold, what would be the triggers, what would need to be the content before you got to a public inquiry stage.
And do you recall that being part of conversations with other ministers?
No, I don't recall that.
Can we just look at one document? It's MACK 40539_002. This is a letter to you and Lord Hunt from Carol Grayson, 18th of January 2003. I just wanted to look at the first paragraph of that letter. In fact, the second paragraph, first paragraph, I'm writing this letter on behalf of a number of haemophiliacs and their families, as many are too afraid to speak out. And then she goes on to say that haemophilia patients have been accessing their medical records because of the US litigation against pharmaceutical companies. And she says this: in the course of this procedure, we are absolutely appalled to find out that in the past there's been testing of haemophiliacs for the hepatitis C virus on a national scale without the express permission of the patient and without any pre or post test counselling being offered. In addition to this, the results of these tests were withheld from the patient, often for several years. The next paragraph, haemophiliacs have long suspected that they had been tested without their knowledge years before they were told of their condition, but until they accessed their notes, we did not have the written evidence. And then if we can just turn over, please, to page 4. The last paragraph on that page, we demand the government holds a full and open public inquiry into the contamination of haemophiliacs with HIV and hepatitis C and into the medical treatment of haemophilia patients. Haemophiliacs are currently seeking legal advice on treatment as they are alleging medical negligence and professional incompetence on a large scale. In many cases, there's a complete breakdown of trust between doctors and patients. Patients are so distressed at their treatment at the hands of the NHS, they are afraid to go to hospital and are in fact cancelling appointments. Now, you were asked about this when you drafted your witness statement, and I think you said you don't think this letter would have got to you. Is that right?
As far as I'm aware.
If you had been provided with information to suggest that a number of haemophiliacs were alleging that as a result of having looked at their medical records, they discovered they'd been tested without their consent, diagnoses had been withheld from them for many years, and all the matters that are set out that I've just read, and that was causing ongoing problems with their treatment. Do you think that would have been something that may have caused you to reconsider whether or not there should be a public inquiry?
I don't think so. I think what it would have made me do is want to look into that, to get the facts, to find out exactly the nature and the extent of the allegations that have been made, whether they were substantiated, and if they were, then that would be an extremely serious matter. I don't think that as a single issue would necessarily have brought me to the conclusion that there should be a public inquiry. And I noticed from Mr. Milburn's evidence that he talked about the possibility of there being a kind of more formal approach to what should trigger a public inquiry. And I think at one point he suggested whether or not there should be almost a legal panel that looks at the allegations, certainly that have been made, and then if on the totality of that it passes a threshold, then that might be a more systematic way of deciding whether or not a public inquiry, because in my admittedly limited experience, it does seem to be that a particular Secretary of State takes a decision and it's a fairly, not ad hoc, but it's in the light of the circumstances of each individual event, and having some systematic way of saying what are the factors that would take you over the threshold for perhaps moving from an internal inquiry to an external inquiry to a public inquiry, I thought was quite a sensible suggestion.
And looking back now, do you think that the sheer number of people infected with life-threatening viruses as a result of their treatment from blood and blood products was reason enough to have held a public inquiry? Do you think that the line that was taken during your time was wrong?
No, I don't think that the line taken was wrong. I do think that a public inquiry, is merited in certain circumstances, and this public inquiry, is doing an extremely thorough job of shining a light on the decision making and the criteria. I don't think it's necessarily about the numbers. I think it's also about the depth of harm as well, and obviously people have suffered tremendously through what was basically a tragedy that occurred to them almost in a double way, from their original haemophilia and then either HIV or HIV and Hep C. It's a terrible cocktail for people to have had to endure. And I would feel more comfortable if public inquiries did have an element of an external view of whether or not it's the appropriate next step, rather than simply being perhaps a ministerial decision.
I'm just going to ask you some questions now about what became known as the Bergen Report, so the report into self-sufficiency. Can we look, please, at WITN 6658019? So this is a submission that's sent up to you from Robert Finch on the 27th of June 2002 about a meeting between Lord Owen, Lord Morris and Michael Connaughty about self-sufficiency in blood products. And it's really the second page that I wanted to draw your attention to. Further investigation. When we met Yvette Cooper to discuss handling, we agreed that officials would undertake a detailed review of the surviving papers between roughly 1973 and 1985 and put together a chronology of events. Without this, it would be difficult to answer any detailed accusations levelled against the department by Lord Owen and others. However, given the need to recruit someone to do this work and the huge volumes of paper to be read and analysed, a complete chronology is unlikely to be ready for at least 4 to 5 months. Now, we've heard evidence, the inquiry's heard evidence from Mr. Lister that he had done an initial trawl of the papers before your time, and he had discovered that some of the submissions that he would have expected to see on the official files were missing. Do you recall whether or not you were told about that? That's not clear from this. It doesn't seem to be information that's being passed on to you as a result in this submission, but is that something that you knew about?
No, I didn't know about that until you just told me.
And you said in your witness statement that from your reading, or that you think that the terms of reference for this piece of work that's being discussed here, which I've called the Bergen Report, were set before you came into your ministerial post. Is that right?
Yes, this was instigated by Yvette when she was PSPH.
And you've also said, is this right, that you don't recall any suggestion being made as to whether or not the loss or destruction of documents should be included within the terms of reference?
Yes, that's correct.
Now, Charles Lister told us that he received the first draft of this report in December 2002, so while you were still Minister, but he didn't take any action on it until the 10th of June 2003, so that's 3 days before you went to the Home Office. Did you ever see a draft of the report?
No, I didn't.
And you were asked questions by the inquiry as to what part the fact that that report was underway during your time in the department, what part that played in the government's calls to resist a public inquiry.
Well, I as far as I can recall, there was a desire to try and get to the bottom of whatever documentation there was that might help us to resolve these issues. And I think it was a really good suggestion by Yvette for there to be a trawl of the papers so that we could see what evidence there was in there. The only results that I got from it before I moved on were really about the fact that Lord Owen's allegations, if you like, about the self-sufficiency issues were explained to me that there was an increase in self-sufficiency, that there was a massive increase in the number of units of blood that were able to be supplied, and that was really the total information that I received. So the report didn't deal with Lord Owen's suggestion that papers had been destroyed, and marginally dealt with the fact that the money that was allocated had actually been spent in the way that it was intended to be, which was to increase the amount of blood products that could be supplied. Unfortunately, we didn't reach self-sufficiency because, as I say in my statement, the demand for clotting factors grew exponentially and it was impossible to keep up to date with it. But the review of the papers, I think, was an excellent idea, but I didn't see the totality of what was found.
What you said in your witness statement was the fact that this report was underway, was being written while you were in post, was another reason relied on by the department as to why a public inquiry shouldn't be called. Is that right?
Well, until the report was, the investigation was completed, there may well have been things that emerged that would affect whether or not a public inquiry should take place. So I think that was a reasonable kind of way of putting the position that until that was available, it was impossible to take a full view on whether or not a public inquiry was appropriate.
So those are the questions that I intended to ask Ms. Blears. I wonder if we could have a break so that call participants can suggest questions to me.
Yes. How long do you suggest?
So I don't know. I know I've had a few questions already. So we could try for 20 minutes and see if we can get back by 5:30.
Let's do that and come back not before 5:30. I'd say not before because it's possible that we may need more time. If so, you'll be told. So will those in the room. If it is time enough, we'll be back then. And I can't tell you, I'm afraid, how long you'll be detained after that because it depends how many questions there are.
I understand.
5:30, not before.